Happy Martin Luther King Day, everyone. It is so meaningful to commemorate with you the great legacy of Dr. King and to remind ourselves that at the core of his famous I Have a Dream speech was his statement that when the architects of our republic drafted the Constitution and the Declaration of Independence, they were signing a promissory note to which all Americans would become heir. I thought it would be meaningful to begin with a phenomenal reading of the I Have a Dream speech that a group of students and live actors did at the National Constitution Center just 2 years ago. Kerry, is it okay if I screen share and do that?
Absolutely, I love that idea.
So when I saw it the first time, I was incredibly moved, and I know you'll find it meaningful too. So here we go, and it's just make the.
I have a dream that one day this nation will rise up and live out the true meaning of its creed. We hold these truths to be self-evident, that all men are created equal. I have a dream
that one day on the red hills of Georgia, the sons of former slaves and the sons of former slave owners will be able to sit down together at the table of brotherhood.
I have a dream.
Wow, it's extraordinarily powerful. The whole thing is worth watching. Madison, I feel the same way about tearing up every time I see this. And what our job today, in addition to being moved to giving thanks for the blessed life and extraordinary inspiration of Dr. King and a resolution to live up to his dream, is to understand his constitutional legacy. What did he mean when he said that he dreamt that someday the promissory note of the Declaration and the Constitution would be made real? And how was that promissory note, how did it start to be redeemed by the Civil Rights Act of 1964 and the Voting Rights Act of 1965? In order to tell that story, we need to go back to the Civil War. And I'm going to try to tell you, or review, because we've talked about some of this before, as concisely as possible, how Abraham Lincoln stood in front of Independence Hall in 1861 and promised to resurrect the promise of the Declaration of Independence and its promise that all men and eventually women are created equal. And how Lincoln said, I would rather be assassinated on this spot than abandon the principles of the Declaration. And yet the war came, as Lincoln said, and after the war, Lincoln was indeed martyred, and some of the promise of the Declaration was enshrined in the 13th, 14th, and 15th Amendments to the Constitution, which of course ended slavery in the 13th and promised equal protection of the law, equal privileges or immunities of citizenship, and guaranteed that no citizen could be deprived of life, liberty, or property without due process of law in the 14th, and then granted voting rights to African-American men in the 15th Amendment. And yet, soon after Reconstruction came what has infamously been called redemption. That was the Southern backlash against Reconstruction, which eviscerated the promise of the amendment. Redemption took many forms. It took political forms. We've been hearing a lot about the contested election of 1876 recently, because that was one of the most contested elections before the election of 2020. In 1876, the loser of the popular vote, Rutherford B. Hayes, was chosen president by a special electoral commission set up by Congress in exchange for the promise of the Republican Party to stop enforcing Reconstruction and to withdraw federal troops from the South. This compromise of 1876, as it was known, effectively neutered Reconstruction and made it impossible to enforce the Reconstruction amendments. But there were a bunch of infamous legal cases as well, which eviscerated the promise of the amendments. The slaughterhouse cases, which we have talked about, nullified the privileges or immunities clause, the Privileges or Immunities Clause was intended by John Bingham and the other framers of the 14th Amendment to guarantee to all citizens, African American and white, the same privileges or immunities and basic civil rights. This included most of the guarantees of the original Bill of Rights, such as the rights of freedom of speech and the rights of fair criminal procedures. And yet the slaughterhouse cases read the clause so narrowly that it didn't protect any meaningful rights at all. And it took nearly 100 years to begin to incorporate or apply the Bill of Rights against the states. Then there was the civil rights cases of the 1880s, which effectively struck down the Civil Rights Act of 1875. And this is important because where the place our story is building to is the Civil Rights Act of 1964, which said that you can't discriminate in basic civil rights on the basis of race. Why did we have to wait 100 years for that when Congress in 1875 passed a law saying that there could be no discrimination in basic civil rights in places of public accommodations, theaters, and other public conveyances? Well, this bill was so important to Charles Sumner, who is its major architect, that on his deathbed, you may remember Charles Sumner, he was played by Tommy Lee Jones in the Lincoln movie. On his deathbed, Sumner said, my bill, don't let them forget my bill. And then he expired. That's how important it was to him that this bill be passed. And it was passed during the brief shining moment when there was still a majority in Congress for Reconstruction. And yet the Supreme Court in the infamous civil rights cases said that Congress had no power to ban discrimination in places of public accommodations because they were effectively forms of private action. Theaters, public conveyances, and railroads are owned by private individuals. And the court said that the 14th Amendment only forbade state action. No state shall deprive any person of equal protection of the law. Now, there was an amazing dissenting opinion in the civil rights cases by Justice John Marshall Harlan. Justice Harlan was also the heroic dissenter in Plessy versus Ferguson, the case that a few years later would uphold segregation in railway carriages. And Harlan had a writer's block. He couldn't, the right words didn't come to him. His wife, recognizing that he was stuck, went to the Supreme Court and found the inkwell that Chief Justice Roger Taney had used to write the infamous Dred Scott decision. And when Harlan came back from church, he went to his writing desk and he found Taney's inkwell that his wife had placed there. And he feels a sense of divine inspiration. And he's so moved that the words come flowing out of him. And he says it is far too artificial a construction to imagine that only the government is bound by the 14th Amendment, because after all, railroads and theaters and other public conveyances are quasi-state actors. They exercise with licenses from the state. They couldn't operate without state support. And therefore, because they are quasi-public entities, they should not be allowed to discriminate. And Harlan predicts that someday the civil rights cases will be overturned. And then similarly in Plessy versus Ferguson, remember, the majority of the court upholds supposedly separate but equal railroad cars that are enforced by the newly Jim Crow South. And Harlan says, in the eyes of the law and the Constitution is colorblind and neither knows nor tolerates classes among citizens. There is no caste here. And he rejects the majority's argument that if African Americans think that there's some inequality by enforced segregation, it's their problem. That's just the construction they're putting upon it. Harlan says everyone knows what the real purpose of segregation is. It's to signal that African Americans are inferior and are not fit to ride with white people. And again, he predicts that that decision will someday be overturned. Okay, fast forward to 1954. Thurgood Marshall, the great advocate and head of the NAACP Legal Defense and Education Fund, reads Harlan's dissenting opinion aloud or to himself for inspiration before he argues Brown versus Board of Education. And Charles Hamilton Houston is one of his mentors, the brilliant dean of Howard Law School. William Hastie is his colleague. And this legal team has spent the 1950s carefully creating building blocks of legal precedent. Marshall, who's a brilliant strategist, knows that if he starts with schools, he's going to lose in court because that's the most controversial thing. So he starts with less hotly contested forms of higher education, in particular law schools, since fewer people go to law school than go to high school. First, in the Sweat v. Painter case, he challenges the separate but equal, supposedly, law school set up by the University of Texas, which isn't equal at all. It's this completely inferior alternative that Texas cobbles together in the face of a lawsuit. And the court strikes that down. It says this isn't true equality. There are certain things that are hard to quantify, but everyone knows are important, like prestige, like the quality of the alumni network, and none of those are present with this makeshift law school. That's the building block for Brown. So Marshall reads Harlan's opinion aloud, he argues Brown, and in Brown, the court unanimously strikes down segregation on the grounds that public education has become such a central, important function in the 1950s that regardless of what the framers of the 14th Amendment thought about the status of public education, which was not widespread in the 1860s, equal access to education has become a fundamental right, and to segregate schools can create feelings of inferiority in the hearts and minds of African American students that violate the equal protection of the law. So that's Brown. And then, of course, there's yet another backlash. You've heard this story before. The Southern states signed the infamous Southern Manifesto, refusing to abide by Brown. When governors try to integrate, there is resistance. Some Southern governors try to refuse to integrate. In the Cooper v. Aaron case, President Dwight Eisenhower has to send the National Guard to Arkansas, where Orville Faubus, the segregationist governor, is standing at the school door and saying we'll never integrate, but the National Guard ensures that the rule of Cooper v. Aaron, namely that integration must take place, is enforced. And the justices are so afraid that their order in Cooper and Aaron won't be enforced that they sign the opinion in pen with their signatures because they are determined to show that they mean business. And thankfully, President Eisenhower supports them. A reminder that the court has neither purse nor sword and cannot enforce its decrees by themselves, but needs help from the political branches. I will pause and we can talk about the crucial role of the civil rights movement in enforcing the promise of Brown, because courts cannot act alone. Justice Ruth Bader Ginsburg used to say this all the time, that although Brown was important, it took the civil rights movement and the engaged activism of freedom riders and heroes like John Lewis marching at the Pettus Bridge, and James Meredith, who forced the integration of the University of Mississippi under the protection of federal troops, and Dr. King, who in 1963 gave his immortal march on Washington and gave the I Have a Dream speech. It took all of that political action to mobilize Congress to act. It was on August 28th, 1963, at the Lincoln Memorial that 250,000 people came for the March on Washington for Jobs and Freedom. And it was King whose I Have a Dream speech captured the public imagination. And that was when he said that the promissory note of the Declaration and the Constitution was a promise that all men, yes, Black men as well as white men, would be guaranteed the unalienable rights of life, liberty, and the pursuit of happiness. It is obvious today that America has defaulted on this promissory note insofar as her citizens of color are concerned. And it was John Lewis who wanted to give one more provocative speech saying that time will come when we will not confine our marching to Washington, but we'll march through the South, through the heart of Dixie, the way Sherman did. But he worried that the speech would alienate white supporters and derail the push for the Civil Rights Act. So he gave a more conciliatory speech, and that culminated in the Civil Rights Act of 1964. Lyndon Johnson promised upon becoming president on the assassination of President Kennedy to pass the Civil Rights Bill. He used his reputation as a former Senate Majority Leader to overcome the filibuster. And the Civil Rights Act passed on July 2nd, 1964, after a 54-day filibuster by a 73-27 vote in the Senate. Title II of the Act banned discrimination based on race, color, religion, or national origin in hotels, motels, restaurants, theaters, and all other public accommodations engaged in interstate commerce. Basically, it sounds a whole lot like the Civil Rights Act of 1875. We just had to wait another 90 years for the Congress to pass again because of the Supreme Court's thwarting the promise. But when the Supreme Court considered the constitutionality of the Civil Rights Act the same year it was passed, in Heart of Atlanta versus US and Katzenberg versus McClung, the court did not rely on the most natural constitutional peg for the Civil Rights Act. That would have been Section 5 of the 14th Amendment, which says Congress shall have the power to enforce this act by appropriate legislation. But because the court in the Civil Rights Act cases had eviscerated Section 5 and suggested that it didn't have broad scope, the court instead had to rely on the interstate commerce clause, the commerce power. The idea was that the Heart of Atlanta was a hotel that refused to rent to African Americans, and the owner, whose name was Morstan Rolston, argued that people aren't commerce, and the due process clause protected a property owner's right to choose to do business to whomever he wanted to. And some folks like Robert Bork, who was a constitutional law scholar, later appointed unsuccessfully to the Supreme Court, agreed that it was the First Amendment right of business owners who didn't want to associate with African Americans to do as they pleased because they weren't bound by the Constitution. And that the Civil Rights Act might infringe their First Amendment rights. But the Supreme Court, with Justice Clark writing and no dissents, disagreed, said most of the hotel's business came from out-of-state highways like I-75, and therefore to forbid African Americans from renting the hotel rooms had an effect on interstate commerce. And in the companion case, Katzenbach against McClung, the court upheld another section of the act banning racial discrimination in restaurants because it also burdened interstate commerce. This was Ollie's Barbecue, a Birmingham, Alabama restaurant on a state highway. The owner said his business is too small and he got so little food that crossed state lines that it had only a minimal effect on interstate commerce. And the court rejected that argument and said, in the aggregate, racial discrimination in the restaurant did have a significant effect on interstate commerce. The discrimination had a direct and highly restricted effect upon interstate travel by African Americans. This was the aggregation principle of Wickard and Filburn, the 1942 case, which said that Congress could regulate a farmer who is growing wheat in his backyard for his own consumption, because even though he was eating it himself, he might not buy interstate wheat, and that in the aggregate, if a lot of people did that, would have an effect on interstate commerce. So that, friends, is the story of the promise of the I Have a Dream speech, the fact that it stemmed from the thwarting of the promise of the Reconstruction Amendments, its codification in the Civil Rights Act of 1964, and its affirmation by the Supreme Court the same year. All right, Kerry, there we go.
Okay. It's been so hard to hold in all the questions from the students and myself. Okay. So one of the things that I found fascinating, so just take a couple more beats on this timeline for everybody, is that you have this big movement of 1964, the Civil Rights Act. Then you have the 24th Amendment, the ending of poll tax. But then, and this is why I picked this picture, and then Selma happens. There's still unbelievable violence towards African Americans and the civil rights movement overall in America. And there's this difference between pushing for civil rights and pushing for political rights and voting rights. And that finally comes through with the Voting Rights Act of 1965. But can you take a couple beats on us? Like, they have to keep moving, and it's not just commerce, it's not just interstate travel with the bus lines, but it is the power to have your representatives represent you and have that voice in picking those representatives.
Voting rights are key. Frederick Douglass, during Reconstruction, said, if we can have the vote, African Americans, This will be a king's cure to all the problems of discrimination. And remember, we talked about early drafts of the 14th Amendment that would have prohibited discrimination in suffrage. There just wasn't enough support for that because it was so the Southerners knew they'd lose political power. They resisted that with everything in their power. The 15th Amendment passes, but it's quickly eviscerated by ruses like so-called literacy tests and poll taxes, which reduce the number of eligible voters to nearly zero. And the Supreme Court shamefully upholds those ruses in cases like the Giles case, where Justice Oliver Wendell Holmes says if there has been a fraud, the court can't do anything about it. So even after the Civil Rights Act of '64, as you say, Kerry, there's huge backlash against voting rights. The white Southerners don't want to give up power. And that leads to Freedom Summer, which was supposed to be a major campaign in Mississippi to register voters with thousands of volunteers from across the country. There's leadership from activists like Robert Moses. They spread out against the country to have a registration drive for voters, but opposition is so strong that only 1,200 Black voters are registered. 3 civil rights workers are murdered in Mississippi. That's dramatized in the movie Mississippi Burning. The murders are committed by KKK members. They pushed the Mississippi Freedom Democratic Party to attend the 1964 Democratic Convention, even though they're banned by the whites-only Mississippi Democratic primary. They're led by Fannie Lou Hamer, the former sharecropper who goes on to co-found the National Women's Political Caucus. She asks, "Is this America?" She demands that they be recognized by the convention. Democratic leaders refuse. And that leads to Bloody Sunday, where Dr. King and the Southern Christian Leadership Conference think another confrontation with Southern justice is necessary to provoke congressional action. That's when in March, James Bevel calls a march from Selma to the state capitol in Montgomery. 600 marchers leave Selma, cross the Edmund Pettus Bridge. Kerry, is that what you have behind you?
Yes, I do. This moment when you walk over this bridge, and place matters in America, so we need to find places. The civil rights movement, it's a constellation of stars across the country, and so you can find movements in your own backyard from Detroit to Texas, East Coast to West Coast. And so when I walked over this bridge thinking of John Lewis and thinking of what they do, it's unbelievable the wave of history that hits you, even though you're alone by yourself on a bridge. And so this is why I picked this one, because we need to invest and understand our civil rights movement in every place it happened in America. So sorry, back to you. Tell the story, it's my favorite, and I can hear it a million times.
I'm so glad you have it. And you crossed the bridge when you visited the Civil Rights Museum a year or so ago, isn't that right? Tell
Yeah,
our friends about the museum.
It was one of, I wish we could spend more time down there, but we went to the Equal Justice Initiative, their main museum and their memorial. It was one of the most moving, hard, and this is hard history. This isn't a moment in time where you're feeling, rah-rah about what we did right. These are really hard stories, but then what you find in there is these amazing people who come back from World War I, come back from World War II, survive those wars, and say, I just fought for freedom for the globe, and now I want freedom in my own country. So it moves you so much to look for the hope and the heroes of America, and to walk in their footsteps is just an honor for all of us.
I'm so glad you're able to see that and to share that experience with our friends. So the Civil Rights Act had monumental effects. The Voting Rights Act. It was signed by President Johnson on August 6th that outlawed literacy tests and other devices which prevent African Americans from registering to vote, and authorizes the Attorney General to send federal examiners to register voters in any county where registration is less than 50%. The results are dramatic, monumental. In 1960, only 20% of Black citizens are registered to vote. By 1971, the number has risen to 62%, while African American officials has quadrupled between 1970 and 1980, doubling again in the 1980s. And as with the Civil Rights Act of '64, the Supreme Court quickly upheld the Voting Rights Act as constitutionally authorized under the 14th and 15th Amendments. In South Carolina versus Katzenbach, 1966, the pre-clearance requirements of the act, which require states to change their voting system if the states use literacy tests and if voter turnout on registration is less than 50% by November 1st, 1964, That's the preclearance requirements. And it also requires so-called covered jurisdictions, in other words, those that are found to have been discriminating when the act was passed, to clear or check any changes in their voting arrangements with the Justice Department before they're allowed to do that. And in an 8-1 decision, Chief Justice Earl Warren upholds the act, this time under the 15th Amendment's enforcement clause, which gives Congress full power to stop racial discrimination in voting. And the Chief Justice says, after enduring nearly a century of systematic resistance to the 15th Amendment, Congress might well decide to shift the advantage of time and inertia from the perpetrators of the evil to its victims. Justice Black is the sole dissenter. He says that Section 5 violates federalism by forcing the states to get the approval of the federal government anytime it wants to uphold its laws. Interestingly, it is federalism concerns that are invoked by the Supreme Court in the Shelby County case, where it strikes down the preclearance requirements. In 2013, those preclearance requirements had been reauthorized by a bipartisan majority of both houses of Congress in 2006, which extended the voting rights preclearance requirements, signed into law by President George W. Bush. And yet the court in a 5-4 decision strikes those down as a violation of federalism, says Congress hasn't come up with good enough evidence that the jurisdictions that discriminated in 1964 are still discriminating. There's a blistering dissent by Justice Ginsburg, her most famous, the one that inspired the notorious RBG meme. She says, just because you're not getting wet in a rainstorm doesn't mean you throw away your umbrella. She said that Congress had an extraordinary amount of evidence that discrimination continued, and she thought that the reauthorization was permissible.
Okay.
There we go.
Questions. Ready for some more questions?
You know it.
Okay, so Jane and Collins both wrapped around the same question in the beginning. I'll read Collins first and then wrap in Jane's. So do you think redemption is an example that the Constitution is truly just words, and if people don't truly believe in them and live them out in our country and our lives, the Constitution is just isn't a true barrier? And I'm missing that last section because there's a thing in my way. Passions of the people will overrule. And then Jane's question was complementary to that. What happens when other branches refuse to help and enforce the decision of the court? So not just if we don't apply it, we don't use it, but then one branch will not enforce the others.
They're crucial questions, and passions of the people is such a resonant phrase. As Colin, as you know, we've talked about Madison's warning that in all large assemblies, passion never fails to wrest the scepter from reason, and it's that fear of unreasonable passions or selfish emotions that animates the framing of the Constitution. So the answer is yes to both questions. The first is that both remind us judges cannot act alone. Meaningful desegregation didn't occur even with Brown versus Board of Education. It didn't occur, that which was the court decision. It didn't occur even after the passage of the Civil Rights Act of 64 or the Voting Rights Act of 65. It took executive regulations passed by the Department of Health, Education, and Welfare, as it was then called in 1968 by the Nixon administration, which threatened to withhold federal funds from schools that continued to discriminate. That was what did it. It wasn't until after those regulations came out that the numbers of segregated schools dramatically decreased and that integration became a reality. So that's a reminder. First, you remember learned hand, liberty has to live in the hearts and minds of the people. First, it took a civil war. It took congressional action of the amendments. They had to be ratified at gunpoint. But then once the federal troops left, then there was no ability to enforce. And then liberty died from the hearts of the people, at least of majorities in control of the Congress and state governments. And we had to wait almost another 100 years for a movement that was driven from the ground up. It was certainly visionary lawyers like Thurgood Marshall, but they were supported by the civil rights movement. And it took the civil rights movement. And pictures are really important. When did public opinion really turn in the civil rights movement? I don't know if you've seen, friends, the really jarring, searing photograph of the police dogs biting the protester. There was something so brutal about that image of racist Southern policemen setting dogs on American citizens that suddenly the North began to pay attention, and that's when public opinion really turned. But even that wasn't enough. It also took, as the second question suggests, commitment of enforcement by the executive embodied in those health and education and welfare regulations, which all goes back to Federalist 78. The Supreme Court has neither purse nor sword. It just can't do it on its own. The justices were scared. In Cooper v. Aaron, when they signed that decision with their signatures, that wasn't a sign of strength. It was a sign of weakness. They were worried that President Eisenhower wasn't going to back them up. Thankfully, he did. But it's such a good reminder. We must study Supreme Court decisions. We've got to familiarize ourselves with the constitutional arguments. We have to read the majority opinions and the dissents. But let's never imagine that constitutional promises embodied in the text are self-executing or are going to just apply themselves. Ultimately, it takes we the people to demand their execution, and it takes mobilization to ensure it.
And we the people comes at all ages, because the pictures that you referenced about Bull O'Connor and others turning the fire hoses and the dogs on the protesters, that was the Children's Crusade. So that was 15-year-olds and 12-year-olds because their parents had been in jail, and they went out and they continued the protest. So when we think about what it takes to have a movement to make change in our country, it takes energy from all the people. And that means some of our youngest are our biggest heroes as well. So I'm glad you brought up that story, Jeff. That's a great one. Wow,
Kerry, that's amazing. I'm glad you brought up the fact that they were teenagers. That's incredibly moving, friends. And it just reminds you, if you need any reminder, you sure can make a difference. You sure can make a difference. And you're doing that by studying the Constitution as rigorously as you are. We know how much you care by taking the time to engage with this class, and your devotion to the Constitution matters.
And now we're both crying, and Colin's pointing out that youth always drive change. So I think that's a great segment that, we on Martin Luther King Day, we remember that it's about service, and it's service to the Constitution, service to each other, and service to our country. So I think it's really important on this day to remember that, and remember it comes at all ages and all sizes and all colors and all places in this country.
I couldn't say it better.
So with that note, Jeff, is there any final words what I think we've been talking about, and we will talk about all week long, is that studying the civil rights movement is studying the movement, the struggle for freedom in America, the struggle for equality in America over time, and then focusing in on those monumental changes that happened from 1940s on, and then asking, how do we play a part in this today? So much Jeff work is assigned at the end of this class. I warned them in the beginning.
Well, there's so much, friends, but you know what I find really meaningful today? Reread the speeches of Dr. King. This great prophet of constitutional change was not a lawyer. He was a minister and a prophet, a man of God, but he had a dream, and his dream was a constitutional dream. And if you read the letter from the Birmingham jail, or the I Have a Dream speech, or any of his many speeches, which you'll find online, just take the time to read a few of them from beginning to end, because you'll see the precision of his belief that the promise of the Declaration could only come through nonviolent protest and change, and also his belief, which he got from the ancient sources, from Plato and Aristotle and the theological sources as well, that only by mastering our unreasonable passions can we achieve temperance, prudence, and justice. So he thought that the crusade for equality and self-government was a struggle that not only had to take place in the halls of Congress and the state legislatures, but in each of ourselves, so that we could achieve what he called agape, or universal benevolence, that Greek word for universal love and benevolence toward our fellow human beings, only by seeing that in the end, we all have the same divine spark that glows within us. And no matter what the color of our skin, it is the content of our character that unites us. That was this inspiring spiritual dream that Dr. King had. And each of us has an opportunity to attempt to live it every day. So read his speeches, and I hope you'll be inspired to live up to his shining example.
Thank you, Jeff. That's a great way to start the Civil Rights Week, a great Martin Luther King Day, and thank you so much.